to be specific as far as the relationship, what I have to say to Sydney Hammond, which is actually being some patience as far as stating some facts as far as years and individuals. In 1995, I believe that Sydney Hammond should not be appointed to the appeals court. I think she lacks integrity and partiality required of the justice of the district court, let alone the appeals court. For more than a decade, I've been a victim of a campaign of harassment, persecution, malicious prosecution, constitutional rights violations under the leadership, guidance, and instructions of Sydney Hammond, largely due to my opposition to the discriminatory practices of the issuance of restraining orders under 209A in the Dorchester District Court. It all began in 1995. I ended a relationship with an ex-girlfriend. On account of her threats, I attended a restraining order, put the court on notice that I was concerned about physical conflict, plus the relationship. She was physically abusive. I finally got a restraining order on February 8th of 1995. In violation of Section 3 of the statute, the next day they issued a restraining order to the ex-girlfriend. Under the instructions of the clerk magistrate at the time, Mr. James Buckley, I filed a letter to the appeals court stating that I wanted to appeal the restraining order. They took it as an appeal and denied me. Immediately after, in May of 1995, the ex-girlfriend filed for a dismissal of the restraining order. What has been, I will further expand upon common practice in the district court, Dorchester District Court, is I wasn't notified of the hearing. When I didn't show up, she was granted dismissal. Immediately, I became the subject of complaints of telephone calls residing by the house. As a result of, the end result of everything in 1995 was that I was given a permanent restraining order was issued against me, again, in violation of a firm case law. I lost my firearms. I was in the military for 9 years. I am not a firearms buff, but I believe in support. I believe in the right to carry firearms. And to this day, according to the rules of appellate procedure, I've never been given an opportunity to appeal the restraining order from 1995, and every effort has been made to deny me the right to appeal this restraining order. It was discovered several years later that all the tapes that I had ordered were either blank or they were doctored and edited. That was from an independent party because, as a result of this ordeal in 95, I was incarcerated for 1 year in Suffolk County House of Correction. As a result of the experience, it took a significant amount of time for me to consider a meaningful romantic relationship. I finally, in 2002, I got into such a relationship. Part of the relationship was my own child. The relationship ended in 2003. Because the mother was not allowing me to see the child, I filed a complaint in Suffolk Probate Court for joint custody and visitation. I filed this complaint April 4th of 2003. The hearing was scheduled for May 13th. On May 5th, the mother of my child went to Dorchester District Court to obtain a restraining order. The excuse used, the affidavit states that I came to the house and said, if you don't sign a piece of paper saying you grant me rights to see my daughter, I'm going to kill you and one of your kids. They issued the restraining order, the ex parte restraining order. I received notice of it. On the 9th and on the 16th, I tried to reschedule the order because I had a hearing in Taunton District Court for disorderly conduct for an event hanging out with a friend at a nightclub. The clerk at the time, Leslie Martinez, refused to allow me to reschedule the hearing. I couldn't be there. So they issued a restraining order. At the time, the justice of the hearing was Rosa Miller. She was aware from a motion for a new hearing date that I filed that I couldn't be there if I was in Taunton District Court. They extended their order for 1 year from that date. So I filed a motion to dismiss and vacate, which came before another judge, Timothy Gary. And again, violation of case law as well as 209A. He extended the order a year from that date, which gave a lifetime of 13 months. Now, I don't mean to keep going on the names, but the problem is that as first justice, I brought all these issues to Justice Hammond, and she is just outright said, I'm not going to do anything. And I have the documentation for that, the correspondence from her saying such. This restraining order from June 18, 2003, I was denied the right to file a notice of appeal for the clerk, Leslie Martinez, refused to allow me. For 3.5 years, I was denied an appeal. Repeatedly, I contacted First Justice Hanlon, Clerk Magistrate Anthony Owens at the court. I filed actions in the appeals court, trying to force Dorchester's court to assemble and forward the records to the appeals court so I could fight the restraining order. In 2005, I finally had to take the matter to the federal court for violation of my constitutional rights, due process rights. It was at that point that the record was finally assembled and forwarded to the court. So, on June 18, 2003, June 18, 2004, December 16, 2004, and December 16, 2005, those 4 hearings, I've never been granted an appeal. December 15, of 2006, a permanent restraining order was issued. And again, in violation of current case law as well as the statute. During the interim part of that, in 2005, I went before the SJC. Now, this can be considered indicative of the state of mind of the Commonwealth of Massachusetts. I went before the full panel of the SJC. Chief Justice Marshall specifically asked me, why are you doing here? Because the requirements are that you go to the appeals court first. I said, I can't. I try to go to the appeals court. This court won't forward the record. The appeals court said they won't take it out the record. And their decision, which is recorded, Chief Justice Marshall said the matter is dismissed because he should have went to the appeals court. So I was in catch-22. And I only bring these issues up to show that Justice Hanlon has been able to continue this abuse of office, discrimination against men, because there's been no checks and balances. There's no repercussions, just like any other abuse of office. And unfortunately, this led into a campaign of harassment, not only by other clerks, and other justices of Dorchester's court, but other branches of the Commonwealth. Since 1995, any criminal offense an individual commits against me, the case is dismissed. In 2002, the uncle of the mother of my only child made pedophile actions to occur to her 3 sons. We had a physical altercation, he lost. The next day he came smashed all the windows on my truck. There were more than 11 people in the area, as well as photos of the incident. Suffolk County DA's office dismissed the matter. The ex was calling me and has stolen my property again. The case was dismissed. Very briefly, because I want to bring documents, physical documentation to support everything I say, but very briefly is that I feel that this would be a bad selection because, just like the others, I have personal experience that a mayor does not get partial interpretation of law before Chief Justice, before Justice could be handled.
Thank you very much. At this time, we're going to break. The Lieutenant Governor, I believe, will come in momentarily. I could take you folks and stay here. You can go outside, but we should resume within, I think, 15 minutes.
Meeting of the pledge.
Recognize Councilor Manning for motion to record advice and consent to the pending list of notaries public and justice of the peace. Second. Second by Councilor Callahan. I recognize Councilor Delaney for motion to record advice and consent to the appointment of James Arnolfi to the position of Associate Justice of the Appeals Court.
I make the motion. He is an excellent nominee, and I'm very proud to be his nominee.
Second by Councilor Manning. Councilor Merrigan?
Yes. Since I've been a Governor's Council member, there have been 5 nominations to the appeals court, and 4 of them have been from within 10 miles of this building. 2 of them have been That said, all of the nominees have been extremely qualified and well-deserving of appointment. However, I'm extremely disappointed that of the 25 justices who sit on the appeals court, only one, Joeu HanlonHearingParts1014218, appointed in the year 2006, is the only one from Western Massachusetts. In the 4 western counties, we have many qualified trial court judges. We have many qualified practicing attorneys who are ready, willing, and able to serve on the appeals court. Diversity of geography and region are essential to our judiciary, and there is a glaring need for geographical diversity in our appellate courts. In March of 2006, at the swearing-in of Justice Joeu HanlonHearingParts1014218 in Northampton, then Chief Justice Armstrong declared that the appeals court should reflect the makeup of the bar of the entire Commonwealth. To him, there appeared to be a structural defect in the system, perhaps what he called systematic factors that accounted for the absence of Western Mass appointments in the appeals court. I make these comments because I am sure, and I speak on behalf of my Western Massachusetts constituents who are deeply concerned. These comments made, however, and these concerns notwithstanding, I want to be very clear that the Governor and the Lieutenant Governor and this administration have been very attentive to trial court vacancies in Western Massachusetts. I speak on behalf of my constituents and say that we in Western Massachusetts are very aware of and grateful for the attention and concern of Governor Patrick for Western Massachusetts trial court vacancies, and we do appreciate it.
I'd just like to make one comment. I just want good people. Excuse me. I just want good, honest, ethical, qualified people to be on the bench. And I really am not concerned where they're coming from in Massachusetts, as long as they have the correct temperament and demeanor and are good, honest, ethical people. That's what I'm looking for. I'm not looking for them to all come from my district. I think we should find the best wherever they are in the Commonwealth. Thank you.
Councilor Lane. Motion for recorded voice. Roll call.
Councilor Viola? Yes. Councilor Templeton?
Yes.
Councilor Bennett?
Yes.
Councilor Ayala?
Yes.
Councilor Manning?
Yes.
Councilor Callahan? Yes. Councilor Merrick?
Yes.
Motion for advice and consent to the appointment of Lauren Cloud to the position of Associate Justice of the Harlem District Court.
I so move.
Second by Councilor Viola.
Discussion.
Councilor Manning.
First of all, I'd like to say that this vote was supposed to come out 2 weeks ago, and there was no provision to table a vote when it comes up, and the meeting was adjourned before the vote came up. And for no reason, last Wednesday, it was canceled again, which this is unprecedented in all my term to see something like this, obviously to ensure the vote for Laurie McLeod. I did give a statement when everyone quickly left the chamber when I was ready to vote, and it was adjourned, so I will make that statement again. I actually have 2 statements if you give me that privilege. The Governor's Council is going to be asked to vote to give advice and consent to Laurie McLeod to the position of Associate Justice of the Foundry District Court. Although this nominee has been an ongoing candidate for a judgeship, applying a number of times, she has continually donated to Massachusetts candidates, including Governor's Counselor and former judge, Counselor Thomas Merrigan. As the sponsor, I requested, and it was put in force by a former governor, and I thank Governor Patrick, too, for adopting in his executive order. I asked him to prohibit any judicial nominee from giving contributions to sitting governor's counselors, governor, and lieutenant governor. When I first got elected, nominees sitting there were giving political donations to the governor's councils right up to the hearing. So my intent was that judicial nominee be prohibited from donating to counselors, sitting governor, and lieutenant governor from the very first time he or she applied for judicial appointment. Not to be allowed to keep giving contributions when they kept applying for a judge. When I met with Attorney McLeod, she said that it's her goal to be a judge, and she's going to keep trying, and she did, and she kept giving contributions to her governor's counselor. In the counselor's questionnaire, the nominee is asked to state the political contribution she has given during the preceding 3 years. She she did say that she gave $250 to Council American. But for the amount of what she put in the questionnaire do not match when you check the Office of Campaign and Political Finance. They're very different. If Attorney McLeod cannot keep track of how much he contributed to political candidates, how can she be expected to keep track of the daily business and details of the court, information that holds the lives of those before her in her hands? Just to cite one donation for a political candidate, Attorney McLeod gave $150 to Governor's Council American in 2005. I have it right here, December 13th. She did not disclose this in her questionnaire, where there was question 6 to give any additional information. And although I met with Attorney McLeod for over 2 hours, she didn't disclose important information that was discovered at her hearing. When she was questioned, she stated that in December 2005, she gave $150 to Thomas Merrigan, Governor's Council Committee, after she received a letter soliciting funds from his committee. When asked at the hearing why did she disclose that she recommended Council American's services as a lawyer, she gave a client to him for a personal injury, and if successful, they will both financially gain. She will get a third of that. And this was in 2005. But guess what? Judge Merrigan gave us a letter on that day, and he said, because I said he shouldn't preside over a hearing, he shouldn't vote. But he gave us this letter on that day that he gave Lieutenant Governor, and he said she gave him the referral, and she gave the donation before he was a candidate, and it was didn't announce in 2006. This is all the contributions he got in 2005. He opened his campaign July 2005. So it really saddens me that we have a former judge who's not telling the truth. She was nominated by the governor on January 5th, but not until March 4th at her hearing, Councilor Merrigan gave the council copies of that letter and that he asked an opinion of the Ethics Commission. He stated that he made the disclosure that McLeod had appeared before him many, many times in 10 years when he was a judge. He also disclosed that in mid-2005, Attorney McLeod recommended his service on a referral fee basis. At the hearing, I stated that Merrigan should recuse himself because it's a violation of 268A, unduly influenced. And one important note, when one asks an opinion of the ethics, shouldn't the question be posed in an honest manner? He said that he didn't announce for Governor's Council until 2006, but he raised over $22,000 in 2005, and he also had a fundraiser in December, and she gave money because she got a fundraising credit. The fundraiser was December 13th. So, there must be many qualified people living in this area in western part of the state, but we seem to be getting nominees from Greenfield, friends of Council American. Last one was William Mazanick, who was Merrigan's tenant, his landlord, and shared office space. And after the vote for Mazanick, the council stood up proudly and stated that Mazanick was his close personal friend for over 20 years. Yes, Mazanick told me he wasn't that friendly with Council Merrigan, that he had a friendship with his father. At Mazanick's hearing, if appointed, I asked, would you recuse yourself if Merrigan appeared before you? And he waited and said, I'll consider it. You know, it's not always popular to do the right thing. And there's rewards and punishment system that goes on right here. And I'm supposed to tell. But, you have to do the right thing. And because of the donations not matching the record for the Campaign and Political Finance Office, upon my request at the hearing, I asked Attorney McLeod to send an attempted explanation of Rivera's donation, and she still didn't explain it. The contributions still do not match the records of the Office of Political Finance. I don't believe for 1 minute that the governor could possibly know what's happening with these nominations, especially those coming from the western part of the state. I ask for transparency. I will not go for this nominee, not because she's just a friend of the counselor, but I cannot, on behalf of the 800,000 citizens in my district throughout the Commonwealth of Massachusetts, and I will be voting no. And I will also submit this letter for the record, where I am noting that Council Merrigan publicly stated that he didn't announce until 2006. He raised over $22,000, opened his bank account on July 16, 2005, and on July 29th, he declared and established an account with the Office of Campaign and Political Finance. It saddens me, Lieutenant Governor, because I believe in the Governor's Council and the responsibility that we've all taken an oath to honor. Councilors went to prison years ago for selling judgeships, and the conduct of this former judge, member of the Governor's Council, should be sanctioned. I'm saddened to report this, but what is. Thank you.
Roll call.
Councilor Viola?
Yes.
Councilor Timmerman?
Yes.
Councilor DeVane?
No.
Councilor Arnott?
No.
Councilor Manning?
No.
Councilor Callahan?
Yes.
Councilor Merrigan?
Yes.
Order.
Meeting is formal assembly is now concluded. Next assembly is Wednesday, April 8th at noon.
Good afternoon. Now we're going to resume the hearing of the appointment of Justice Hanlon to the Appeals Court. Mr. Watson, you had one more thing you wanted to say quickly?
Yeah, very quickly. I appreciate you giving that opportunity. As I said, I don't really much. Very quickly, I just want to say that the offenses committed against me by Justice Hanlon, well documented. Many of the actions are in the appeals court and the Supreme Judicial Court. My problem is that, in addition to the abuse of office and the discrimination, every offense that's been committed to me has never been brought to the appeals court for me to address the matter. As I said, I've had a restraining order since 2003, despite 4 or 5 subsequent extensions. I've never given an appeal. These criminal complaints filed against me to harass me to the district court hasn't been entitled to an appeal. The efforts to try to address some of the actions by years, I think, were working on the instructions and guidance of Judge Hanlon. They've been dismissed and go to the district court, and I've never had the opportunity to appeal them. This, to me, is not I have concerns with domestic violence law, so this is, as I said, I personally been subjected to this treatment. I would ask the court, the governor's council, to take into consideration not just what I say, but I've had the misfortune of finding a case that was filed in federal court for many of the allegations that I have against Justice Hanlon were alleged by another gentleman in 1996. The case was Rodriguez versus Carhart and others. When the case alleged that then prosecutor Hanlon and others doctored the gentleman's case and denied him access to transcripts, etc., in order to impede his ability to represent himself and force his conviction. Now, the matter was dismissed, not on the merits of his claim, but on the federal issue of they stated claim that as prosecutor, someone in the district attorney's office, they're protected by absolute immunity. So I would just like the issue of character of that instance considered. Thank you.
Thank you very much.
Before,
sorry, Councilor Callahan.
You said you went through the federal government and took out a complaint on civil rights discrimination.
Yes.
What was the result of that?
I was dismissed. One, this would be outside of 95. I had to represent myself because of the financial stress that various factors, the developed others have created. So, one, I used the wrong federal statute. Then number two is, at the time of the filing, I was aware of the absolute immunity of judges as well as individuals in the district attorney's office. Unfortunately, that protection has gone so far that anything remotely associated with a judge performing judicial duty and the DA in the investigative process or prosecution of the case, they have immunity, so that's why the case was dismissed.
So the federal government did not find that there was any statutory immunity for the judge?
No, that was not the case. So it was just a matter of it being dismissed because they say...
Well, they either did find that or they didn't.
No, it was just a matter of jurisdiction. They said, according to federal law...
Well, jurisdictionally, they didn't find anything wrong with that.
No, that wasn't the case.
The federal government accused the judge.
They didn't address the issue, just because of the fact that she has immunity, just like the DA, so it wouldn't be considered. It's much, I guess...
The judge had immunity for the
Unfortunately, this is true. As a private citizen, I can't prosecute or file a complaint against a justice or a district attorney. However, the federal government, the Department of Justice, can do it. Unfortunately, I've addressed the issue with the Department of Justice as well as the FBI. But if you know the background of Justice Hanlon, she worked in close association with these departments. Some of the cases were very high profile, not too far related from the Whitey Bulger case. So there's an association there, that I think is tainting their impartiality, because the incidents I said are well documented as far as the denial of a appeal for 3.5 years.
Okay, thank you very much. Thank you very much, sir. Next we'll hear from Doug George. Is Doug George here? Okay, and then is there anyone else who would like to speak? I'm sorry. Denise Barron? Okay, more here now. Good afternoon. Good to see you.
Good afternoon. Thank you for hearing me. I am here in opposition to Joeu Hanlon. I have not personally been in front of her as a judge. I first became aware of her when I went to a meeting about a year ago that was on domestic violence, because I was trying to get some information on domestic violence, and she indicated that she was one of the people who was the architect of the law. And I've since been in Dorchester court with a friend of mine who has been a victim of false allegations. My concern is that I do believe that she really is concerned about domestic violence. My concern, though, is for people who are victims of false allegations, there is not any recourse for people. You have to spend a lot of money hiring lawyers, trying to get, for people. My friend has been in and out of court. His ex-wife has filed false police reports, false allegations, has got him arrested, and there has been no recourse for her. And so I feel like it is not a balanced playing field, that there is a lot of bias against men, and that if you find that you're a victim of a false allegation, there is not anywhere for you to go unless you have a lot of money. And in terms of the Dorchester court, he ended up going to trial. He fortunately was found not guilty because he had an excellent lawyer who is here. But she has also violated his restraining order. And in my experience, from going to the Dorchester court and going to multiple courts, because he's been in multiple police stations, multiple courts in terms of these false violations, when you say to people, well, what are you supposed to do? And that's my question, what are you supposed to do? Nobody's been able to say anything. She's committed perjury on the stand, she's committed perjury in her affidavit, and she was walked around scot-free. He was arrested with his children because she made a false 911 call. There were witnesses at the police station who said that the violation did not take place, but his case did go to trial. So my concern for Judge Hanlon is that there are many people who have been victims of false allegations, and I feel like the statute as it stands right now does not address it. And I am not necessarily opposing the rules that it stands. I am just asking that that they uphold the 3 requirements for issuing a 209A, that you've been in imminent physical danger and that you be able to prove it. She's been able to get restraining orders by providing no proof whatsoever. All she does is she gets up and says whatever. Even now he's been able to produce people who have seen him being assaulted and been able to prove that the things that she is saying have been false. He has gotten nowhere. So I can speak to what has happened to his family and his kids, the toll that it takes on people who are victims of domestic violence. His mother has lost 20 pounds. His daughter, who's an 11-year-old daughter, now believes that somebody can call the police on her and she will get arrested. And I think that's some of the things that people don't realize in this case. It's not only the victim, but it's the victim's families and friends. And it is really huge damage that is being done to people. And all we're asking is that that the law be upheld. Not necessarily that it changes, that the law be upheld and that people be required to prove that they are abused and that they not just be able to say that I am afraid, and that the people who have filed false allegations against false human aids, that there be some punishment for them for doing that and subjecting people to it. So I thank you for your time.
Thank you very much, Councilor Devaney. Councilor Devaney, of course.
Thank you for your testimony. It was very heartfelt, and I think that should be noted. It's just not one person that affected the whole family. So, that's the biggest thing, women lives and what resources we have. I am very concerned about that. Thank you very much.
Thank you very much. That will conclude the people who are here in opposition to Judge Hanlon. At this point, Judge Hanlon, if you want to give us a little explanation as to your work experience and why you'd like to be an associate justice in the case.
Thank you, sir. Mr. Chairman, members of the council, it's a very great honor to have the opportunity to sit in this chair for the second time. After almost 20 years, it's time to speak to you about why I would like to be a justice in the Massachusetts Appeals Court and what I think I could bring to that position. I have been a trial judge and a trial lawyer for 33 years, and I have loved being part of the trial. The Appeals Court makes the rules for the trial and mental health hearing and probation violation hearing and motions to suppress and restraining order hearing that I have spent my life learning and practicing and sometimes teaching. So my dream is to take the experience that I have to that next level, where I would have a chance to do research and refine my writing and work with talented colleagues in a place where no one is pressured to handle a jury trial or clear the locker. I would like to tell you a little bit about myself. I'm an only child born in 1950. The parents who were then in their 40s. Obviously, I came something of a surprise. My father was one of 9, my mother was one of 6. My father worked for a variety of jobs. He never graduated from college, although he was a superb writer. He left the only job he really loved as an administrator for the National Youth Administration in the 1930s and 1940s to enlist as a pilot in the United States Army after Pearl Harbor, even though he was too old to be drafted. When he came back from the war, he alternated between government jobs and company, but he settled in the Social Security Administration in his mid-50s, a job that he hated but kept so that my mother would have a secure retirement and I could go to college. My mom grew up on a farm in Missouri and left high school in her junior year to work for Ford. Her father was murdered when she was 18, and friends of the family paid to send her to business school. She worked until she was almost 70 as a bookkeeper for small electrical firms. Nowadays, I think they call that an accountant, but my mother described herself as a bookkeeper. Together, my parents put their considerable energies into raising and educating me with few resources by today's standards. They both worked full-time. We lived in rented apartments and took family vacations by staying with relatives. And I don't do that. We did go to the beach for a week once when I was 14, but that was no time. Because of my parents' hard work and sacrifice, I graduated from Ivy League schools, both college and law school, without $1 in debt. And although they're both dead now, my parents left me almost 50 cousins. Some of whom are here today, and they are my brothers and sisters, and the children of my nephews and recently grandniece. As you know, I worked as a prosecutor for 15 years, and I was extraordinarily lucky in my bosses and the staff that they put together. There's some times and places that are just special. When a new leader comes in and attracts people from a variety of places, and they all bring great energy and enthusiasm and passion. And that description fits each of the places I had the privilege of working. Congressman Bill Delahunt was the first full-time district attorney in the Commonwealth of Massachusetts, and when he took office in 1975, he hired experienced prosecutors, but also experienced defense lawyers from private practice and from the Mass Defenders Committee. He made local headlines when he announced that he would hire women. Not any particular woman, just that there would be women. He put together an extraordinary collection of trial lawyers who were wonderful mentors to me. I was lucky enough starting out as a brand new lawyer. After a year, he made me the head of the first rape unit in the state. Within the next 6 years, I prosecuted rape and child molestation cases, along with first-degree murders, drug wiretaps, and pretty much every kind of case that comes into a county DA's office. Former Governor Bill Wells also put together an extraordinary United States Attorney's Office, beginning with Robert Mueller, who's now the director of the FBI, chief of the criminal division, and hired, frankly, people who are now the stars of the bench and the bar and law, among the additions including my own boss, Justice Barrett. Mr. Mullen hired me for the Organized Crime Drug Enforcement Task Force in 1982, and I spent 5 years in the Federal District Court prosecuting major drug traffickers and money launderers. And in addition, in that office, you tried the case, you wrote the brief, and you argued it in the First Circuit Court of Appeals, so I had great appellate experience there as well. I left the United States Attorney's Office in 1987 when the newly elected Attorney General, Jim Shannon, asked me to put together a drug investigation and prosecution unit in the Department of Attorney General. I negotiated the return of the state police to that office with 18 assigned drugs along with 5 Boston police officers. And I hired an impressive group of 5 lawyers for the drug unit. One is now a prominent defense attorney, one a professor at Boston College Law School, and one the first justice of the Department of Court. For the next 3.5 years, I supervised drug investigations and prosecutions, and I tried 5 cases of my own. I also drafted and lobbied for legislation, including the statute that made the possession of ecstasy a crime and some requirements of the narcotics forfeiture law. I left the Attorney General's office when Governor Dukakis appointed me to the Dorchester Court in 1990. And I had been there in what I consider one of the busiest courts in the Commonwealth for more than 18 years. I have been the First Justice there for almost 15 of those years. Dorchester gives you a seat on the front line for virtually every conflict that comes to the court. I have enjoyed my time there enormously. I have learned something every day, and I have never been bored for a minute. I didn't think this was going to be fun. I work with wonderful people who work flat out every day to help people and to keep people safe. In addition, in 1992, Chief Justice Stoll asked me to chair the District Court Domestic Violence Committee. I'm proud of all of the work that committee did, but especially for drafting the trial court guidelines for restraining order hearings. We took testimony from others. We wrote a draft. We circulated the draft. We got a lot of comments. We rewrote the draft. We recirculated the draft. We rewrote the draft. Eventually, our draft was cited approvingly by the Supreme Judicial Court in Zadar versus Zadar, and then approved by the NJC as the trial court guidelines for abuse prevention proceedings. It's available on the trial court website, both the guidelines themselves and the commentary, and I encourage anyone who has questions about that document to, it's completely accessible. I believe that it stands up today, after almost 15 years, as a useful and thoughtful roadmap for restraining order hearings, one that seeks fairness and due process as well as public safety. One of the best things about Dorchester Court has been an opportunity to create or to encourage others to create programs that help people. I do think I deserve primary credit for the Dorchester Court Literacy Program, Judge Miller for the Women's Program, Bernie Fitzgerald certainly for the Fathers Program, Judge Bob Simeon for the Drug Court. Several of us, I think, share credit for the Domestic Violence Court. But as First Justice, you can do enormous good, just by giving other people a chance to follow their own good ideas, and by supporting them, and that's what I have tried to do. The result has been that I have had the opportunity to see people do well. This is an unusual experience for a judge. Usually we see only the failures. But I see them not just at the graduation ceremonies for the literature program and the fathers program and the women's program, but also when people finish probation, clean and sober, often working and feeling good about themselves for the first time in their lives. One man with a 6-page record told me that his probation was the first thing that he had ever finished. I live in Dorchester, and I often run into people who know me from the court. It doesn't know anything. I have to check to be sure it's her when they say nice things. It wasn't her when they say nice things. Sometimes they come up to me, and I'm very pleased that almost without exception they want to tell me how that they're doing well now. It means a great deal to me that they know that I care about that. Several people have thanked me for sending them to jail because it gave them time to think and time away from the street and the things that they were involved in. A nurse in my mother's nursing home who was dispensing medication told me that she had graduated from the literature program and that she had her nursing license now. And on one very special February night, I was in the Fields Corner Dunkin' Donuts getting donuts to take to my mom in the nursery. And the young man in front of me in line was fooling around with his child, was laughing and dancing around the store. And you could see from the look on the father's face that he was getting enormous pleasure out of watching his child. And I asked the child if I could tie his shoes because his shoelaces, because they were untied and it was icy out. And I was afraid he would fall. And he said yes. And I was kneeling on the floor at the Dunkin' Donuts tying his shoes while the father paid for the hot chocolate. And then he said to me, say thank you. He said, say thank you to the lady. And then I said thank you. And then the young man looked at me and he said, that's what a father program does. And I asked him if he had done the Dorchester Court Fatherhood Program, and he said, yes, ma'am, I did. And I told him that I knew his face, but I didn't know where I knew him from. And I told him how much I had enjoyed watching him with his child. And I thanked him for telling me. Dorchester Court is a program in place, and I have had a wide range of legal and personal experiences. I think that I have a sense of what works, of how to interpret and apply the law in a way that is faithful to the statutes and precedents, but also encompasses the human experience of the people who practice in the court system and the people who depend upon it for their safety and for their freedom. It would be a great privilege.
Very lots of the trial court casually, but it's also very important, knowing myself, that sometimes the opportunity to change what we do and still be part of the judicial branch is something very exciting and certainly serving.
Thank you.
Councilor Callahan?
How is this split program?
It's 12 weeks. It doesn't cost anything. It's run by, usually run with sometimes one of the assistant chiefs and sometimes the other probation officers. Most of our, it depends. If the judge sentences you to do the program as a condition of probation, that's what you do on probation. Sometimes people volunteer to do it and they get time off their probation if they do it. It's 12 weeks and there's speakers. As Bernie said, always somebody comes from the probate and family court to talk about that court and negotiating that court, because as I said, a lot of people have either restraining orders that order no contact with their children, or and then what, visitation orders, which they don't have the authority to do. So, to see your children. The one people like in particular